This is Colin O'Keefe here for LXBN TV. It's a subject we've discussed a lot lately here on LXBN TV, but last Thursday, President Obama announced his long-awaited executive action on immigration reform. Joining me now from Columbus to discuss the details of this action is attorney Robert Cohen. He's with Porter Wright, an author on the firm's blog, The Employer Law Report. Robert, first off, let's start with what was a big priority for this executive action, and that was deferred action as it pertains to immigrants. What are the steps that the president took when it came to that deferred action and those measures there?
Thank you, Colin. The president's order really recognized the reality that there are approximately 11 million undocumented immigrants in the country, and the ICE, Immigration and Customs Enforcement, has been deporting people at about 400,000 a year, which in the last few years he's received a great deal of criticism because that's really an extraordinary number. But it's still considerably less than the 11 million people that are here. What the president did was prioritize among the 11 million people who he thinks is appropriate to direct his attention to. And for the rest of them, and he defined that class as parents of U.S. citizens and permanent residents, we're not going to enforce and deport them, enforce the law and deport them, because we can't do it for everybody. So while they are allowed to stay here, we're going to grant them work authorization and hopefully pass immigration reform sometime in the future. So what he has said is, while you are here, we're going to give you work authorization and allow you to stay, and we're going to defer any enforcement action. That's essentially what the executive order says.
I see, and that was, again, a big priority there. And of course, your post on the subject tackled kind of what this means for businesses, what this means for employers. So when we look at the deferred action aspect to this, what does that mean for employers? What's your advice? What are the takeaways on that front?
Well, it's going to mean, for a lot of employers, it's not going to have much of an impact. But for those industries where they have been typically reliant upon immigrant labor, particularly in the low-skilled or the lesser-skilled fields, it will make their compliance with employer sanction and verification law much easier. It'll make it possible, actually, and so they will be able to get work out. Excuse me. The individuals will be able to get work authorization, and the employers will be able to comply. For those who have been complying in the past, it is going to broaden their potential workforce, and it will make it easier for them to find the necessary workers. One of the problems that employers are going to find, I'm afraid, is there's going to be a large number of people who are in their workforce who are going to come forward now with employment authorization. And they're going to say some variation of, well, now I'm legal, and here's my real identification and verification. And the implication, of course, is that the last one that they gave wasn't really kosher. And so employers are going to be faced with a dilemma. Will they accept this change, or will they tell employees who have presented false documents in the past, no, thank you? And those are really two different policies. One of them, I guess we could call quickly an honesty policy, and the other is one of greater forgiveness. And there are advantages and disadvantages of both. Our advice to employers is you can do either one, but don't mix and match, because as soon as you start to mix and match, you run into the potential of a discrimination complaint, because maybe it's Mexicans that you're giving forgiveness to and Guatemalans not so much. And you don't want to be making those kinds of distinctions. So you either need to decide you're going to accept the new authorization and engage in a policy of forgiveness, or you're going to hold the line and say, if you've given us false documents, we can no longer employ you.
Absolutely. It's good to have really a policy level decision on those types of things so you're not being reactionary on a situation by situation basis. And then second, in your post on the subject, you also highlighted the memoranda that was put forth by the Department of Homeland Security that got into kind of the details of what this means going forward. So in there, what are some of the biggest items that businesses need to be aware of from that memoranda?
Well, there were a number of very good things that were set forth in that memo. Some of them, frankly, are things that should have been done. Actually, not some of them, all of them are things that should have been done a long time ago. They're not revolutionary. They're merely an appropriate way to implement some of the laws on business immigration that will make it a lot easier. One example that I think is going to be particularly exciting is what they call the expanded use of the national interest waiver. The NIW, the National Interest Waiver, was passed in 1990, the Immigration Act of 1990, and provided for a path to permanent residence for those who will make a significant contribution to the American economy or the American society in general. And this held great promise for those who could make begin businesses, could generate economic growth in the healthcare field, in the environmental. There's a whole range of subjects that some very high-skilled people could use the national interest waiver to achieve permanent residence. Unfortunately, the Immigration Service, the INS, back in the 90s, began interpreting that in a very restrictive way. And particularly, there was a 1998 case, we refer to it as NYSDOT, New York State Department of Transportation, and it severely restricted the use of the national interest waiver. This memo says that it's very underutilized, which is accurate, and we need to figure out how to broaden it and make it possible for all of these very highly skilled and desirable immigrants to be able to use this tool that has existed since 1990 and to achieve permanent resident status. And the fact that we are reinitiating that discussion could be very exciting.
Definitely. It's something worth keeping an eye on for sure. This deferred action is getting a lot of attention, but it's absolutely interesting to keep an eye on what this means in other areas as well, particularly the one that you mentioned there. Once again, that was attorney Robert Cohen of Porter Wright. For his full analysis of what this action means for businesses, be sure to check out his post on the subject. It is at employerlawreport.com. Thank you for joining me today, Robert.
Thank you. My pleasure.